We're here on today, January 21st, 2016. We are fully remote by Zoom. First order of business on our agenda is approval of the minutes. So hopefully everyone has had a chance to approve the meeting minutes from our last meeting. And I would entertain a motion to approve our last meeting minutes.
So moved, Madam Chair.
All right, there's been a motion. Any discussion on approval of the meeting minutes? All right, seeing none, all those in favor say aye.
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 Any opposed, say no. All right, motion carries and the minutes are approved. Next thing on the agenda, let's see. I want to pull up here. We have the unfinished business of the items last time that we were not in agreement with. We had a lot of good discussion. We had a lot of good ideas. And let's see, just pull this up. Okay, I have circulated chair recommendations that I put together following our last meeting and following notes that I took where I thought we had some really good discussion. So hopefully everybody has that. If not, I will be happy to share that. So based on the discussion that we had last time, I've put together recommendations A, B, C, D, and E. The first has to do with the timeline. We discussed various timelines, either having to do with a date certain or sort of a process, and I've taken from the notes kind of both. Unless anybody has any other ideas of where they want to start, I'd like to start working through the chair's recommendations. And then, wait, let me back up. Mr. George, did we have anything to go over from last meeting with wordsmithing, or was that all accomplished?
Not, yeah, just to clarify for the recommendations that were adopted or on this outstanding topic.
On the recommendations that were adopted.
That we can include that for the final draft of the report that will be introduced at next week's meeting, the final meeting.
Great.
Yeah.
Okay, so looking at the Seclusion Working Group Chair's recommendations, paragraph A. Obviously, we've identified, I think everyone agrees, the overarching goal of our discussion is to completely end seclusion in all districts throughout Minnesota. And with that in mind, putting into place some timelines. I'm open to discussion on paragraph A, sub 1 and 2, by which date all districts will have a vetted alternative to seclusion in place. And number 2, all districts will reduce the use of seclusion by some percentage annually until seclusion is used some percentage of the time in any school year. Open this up to discussion in the work group. I'm not seeing any hands. Mr. George, you might have to help me. Oh, here we go. Ms. Chose, I see your hand.
Thank you, Madam Chair. I feel like timing on having a vetted alternative might be best. I'm kind of looking to my education folks on the team. I know that some of you have actually done this, so I don't know the timing, but maybe we can use some of the timing that, like Ms. Woodward had talked about. So I'd love to hear from them.
Ms. Woodward.
Thank you, Madam Chair. I I think that A really does a nice job of capturing the essence of what we were trying to accomplish at the last meeting. I think that when we set deadlines in districts, that creates a lot of challenges for implementation because there's a lot of competing mandates and priorities out there. So for example, when we had to, by certain dates, provide REDAC training, like districts really had to pause all other initiatives to accomplish that task by a said date. And so which could have included initiatives that are related to this concern, right? Like their positive behavior interventions and supports, like really everything had to be set aside to do that. So obviously I'm supporting increasing our implementation of vetted alternatives. It just does create a lot of barriers when it's taken out of context of all other mandates that districts are needing to implement. And how does that play a factor and get prioritized?
Thank you. Any other thoughts? All right. I am not hearing anything with regard to A1 in terms of filling in a date here. Ms. Chose.
Thank you, Madam Chair. I don't have an answer here, and I hear the question about timing. I'm not sure how else to do that with competing priorities. I hear that. I like that this is, that as this is a good reflection of kind of what we were talking about, so I'm really happy about that. And I would like to get some parameters in place and some kind of timeline, deadline, goal in place of ending seclusion. So is there anything else, maybe even a little bit different? I guess I'm not sure. It's kind of out of my wheelhouse.
Yeah, I'm I've added maybe by a certain date, all districts will strive to have a vetted alternative to seclusion in place. I see your hand, Ms. Woodward.
Thank you, Madam Chair. I'm just, it takes a second to kind of process through these things. One suggestion I'll put on the table is if the goal is really to like the outcome that we're measuring is the reduced use of seclusion, one pathway to get there is implementing these alternatives. Again, like we talked about, some districts already have them in place. And so I'm curious if letter A is more centered around number 2 and us talking about that threshold. And one pathway that you could take to get there is adopting a different vetted alternative to seclusion, but perhaps that item is best placed with the responsibility of the department to, again, provide technical assistance options for what those alternatives are. Again, like working with districts who fail to meet set thresholds in corrective action plans, which would then be paired with technical assistance. So that because if a district is able to meet those responsible thresholds, then that's really the goal. And when you're not, that's when we're looking at some of that. So that's my suggestion for the group to consider.
So if we eliminate then, oh, sorry, Mr. Haveman.
Yeah, thank you. Thank you, Madam Chair. I was thinking a little bit about this too. And I think what I'm struggling with is like the finality of having, or the idea of the finality of having an alternative in place versus like getting something off the ground in your district and working on the implementation pieces that are necessary. We have 7 special education programs here at 916, and we are stair-stepping our way through the piloting of UCARU throughout our district last year and this year and also into next year. And so when I think about districts and their various sizes, like Hastings, where I once worked, had 5 total buildings versus like Lakeville, where I worked, had like, 15 to 17 buildings before, depending. And so like, depending on the size of the buildings and all of that, I hesitate to put a deadline in place by which you feel like you're there when it comes to like that alternative versus when do we expect districts to at least have started this work? And how do we maybe pair that with what Nicole was saying when it came to stair stepping down our what we expect to have happen in terms of seclusion and the data, while that is also taking place and the implementation is starting to move forward.
Okay. Ms. Heiser.
Thank you, Madam Chair. I've asked this question multiple times. I need an answer. When is the date that you all will sign off on an end of seclusion in schools? MDE has recommended September 1st, 2026. We have asked for the same thing. I have expressed multiple times being open to hearing other dates. And I need somebody from the school side to say, this is an appropriate date. I mean, we write IEP goals for livings. We know we've got to have a date sometime we're going to do this. And it can't just be, well, let's try and let's put this in place and let's see what happens. I have to have some sort of number to work off of to see if we can come up with a consensus. Otherwise, I think it's just wise to say in the report, some members voted for this date, some members voted for that date, and we couldn't come up with a consensus.
Yeah, and Ms. Heiser, I think I've heard more than once from the school side that a date isn't a practical or necessarily workable goal. Rather, measuring progress toward reducing the use of seclusion will be a more attainable goal. So that's why I drafted this the way that I did. I understand and I've heard you, and I know that there is a push for a drop dead date when seclusion will not be used anymore. I do not think that's appropriate. I think that'll hamstring districts the same as the ban that we put in place in 2023. What I'd like to do instead is to recommend something that is realistic and achievable by the districts, given the resources that they have to work with. Ms. Woodward.
Thank you, Madam.
Oh, okay, Ms.
Sorry.
Holtz. Oh, I don't know who's, Woodward, are you up?
We can go to Hulse. I've taken some airtime. She can go, and then I can go if I need to.
Okay, Ms. Holtz. All right, she disappeared. Ms. Woodward, we're back to you.
Sorry, Ms. Halsey, you might have me muted. Sorry.
I did.
There you
No
are.
worries. There we go. I think I put my hand down and forgot to unmute myself. My apologies. I appreciate your response, Madam Chair, on behalf of the educators. And I just really want to reiterate, that's been our thesis throughout this legislative working group is a date is arbitrary. I recognize that's what the advocates are pushing for, but a date without the technical support and without the runway being built is going to get us more of what we've had, which is shortened days, more police response, and more physical holds. And so while I can understand why the question is being asked and why you want a drop dead date, it's going to get us more of what we've seen with the K-3 ban. And so I appreciate being provided with the space and time to have this level of conversation about this, because I do think that being allowed the stepwise ability to build a system that really gets at what we think we need to reduce seclusion in a way that also sort of inoculates against some of these other also bad, agreeable things that we all agree are also bad outcomes, things we don't want to be doing. As we've agreed, no one likes to use seclusion. I think we can also agree nobody likes to call the cops on students. Nobody likes to put students in physical holds. And yet, without building these viable alternatives, without taking the time to build the infrastructure in our districts of varied sizes and with varied special ed programs, without that, that's what we're going to be seeing. And so I am very supportive of language that says things like, within 5 years, within 8 years of, having vetted alternatives and fully funded programming, and then looking at data that comes in after we have these things fully in place. That's really what I'm a proponent of in these situations. Thank you.
Thank you, Ms. Hulse. Ms. Woodward.
Thank you, Madam Chair. My sentiments are similar. I really think that it's important, before just taking it away, of looking at, like, how do we get there and what does that look like, and how do we continue to narrow in on the very specific programs that may use seclusion and continue to work toward decreasing that number. And that responsibility for that technical support has to be on more than just the districts.
Mhm.
And so I see a pathway. I just, without having commitment or see any progress, I don't know how we're ever going to get to an agreement within this context. And I don't know that that was the charge of the work group, wasn't to say, what date do you agree seclusion will be completely banned? There were many more things that we were charged with to understand and to look at these implications. And so I guess we're not going to get there with agreement. Like, there won't be, I can't say 2030 because I don't know what's going to happen. But if we're looking at thresholds and working with districts and getting to a place where MDE and District A are working together, and District A is able to implement the kinds of supports needed to where all of a sudden they get to 0, then great. District A no longer needs to use seclusion. Now let's look at District B, who has struggled to get below, I'm making things up because we haven't analyzed these statistics, but 10%. Okay, we're gonna focus our resources on District B. They still have a high rate of injury for staff and students, and they're using a high rate of seclusion. And then we work to implement and support there. Oh, then they get down. Now they all of a sudden don't need to. And pretty soon, over time, we get to a situation where our supports are so robust that we don't need it. That's what will work the best. And that's what will set everyone up for success and make everyone feel safe and supported.
Ms. Winship.
Thank you, Madam Chair. I have more of a question is, the research I've done has shown that states that banned seclusion, that there is not an increase in holds. Do we have any data or research that shows that there actually is? Because I think the last report, and I'll have to look at it, I think was from 2024, that showed that there was not more restraints in the states that banned seclusion. So I'm wondering if anyone else has any information on that.
I think what we saw here in the state of Minnesota was just now that we have one full school year under our belt with the K-3 ban, and we've seen an increase in physical holds and an increase in injuries. That's what I remember seeing evidence of. Ms. Hulse.
Unmuting myself this time. There we go. Thank you, Madam Chair. I think that, yes, that is the information that we have from our state. And I think, as we've discussed in the past, it's incredibly hard to compare states to one another because the resources and supports, particularly on the mental health side, the county side, and the other basically outside of school supports look vastly, vastly different state to state. And so what other states may have, we do not necessarily have here in Minnesota. And I will just quote Sue Abderholden, previous director from NAMI, one more time and say, we just never fully finished building the children's mental health support system here in Minnesota. And it really shows, particularly when we talk about those students in setting 3 and setting 4, when you're really struggling in those settings and you have needs that are significant and you need supports that may go beyond what you can get even in a setting 3 or setting 4 educational setting, you can be very hard pressed as a family. And once again, Madam Chair, I know I'm not telling you anything you don't know. And I know for some other members of this group who are parents, I know I am not telling you anything you don't know. But that's why I think it is so very difficult to do this state by state comparison. But in our state, it remains very, very problematic and a struggle for families and caregivers to find supports that they need. And our reality is that our students do often see an uptick in physical holds, shortened days, home-based placements, and again, law enforcement intervention.
So looking at paragraph A that I've been revising while we've been talking, and considering the notion of benchmarks and more of a tiered process. First sentence I've got, with the overarching goal of completely ending seclusion in all districts throughout Minnesota, all districts will reduce the use of seclusion by 50% annually until seclusion is used less than 5% of the time in any school year. What do we think about those? Is that a workable metrics? Is that, I don't want to set districts up to fail, but I want to have something that we can look at to measure success. Ms. Heiser, I see your hand.
I guess my question is, what is our goal today? Are we trying to reach consensus on these topics together and then we're all going to vote together? Or are these the chair's recommendations that will be placed in the report separate than the consensus that we built on the previous 5 pieces? And with the acknowledgement that like, we're just not going to get to a consensus on these pieces.
We're not going to get to a consensus on these pieces. That was made clear at our last meeting. These are the remaining issues that we do not have consensus on and will not reach consensus on. So what we're going to do is we're going to vote on chair's recommendations A, B, C, D, and E. And if they pass, they will become recommendations of the working group. And if they do not, then they won't. And if there's any other recommendations anybody wants to offer, we can consider those as well. And then at our next meeting next week, we will go through the draft report and vote on it at that time.
Well,
Mr.
then-
George, do I have that right?
Madam Chair, that process you laid out works. Whether the vote is today at the beginning of next meeting, yes, yeah.
Okay, Ms. Hulse?
I'm sorry, Madam Chair, can I just ask a follow-up real quick?
Sure, Ms. Heiser?
Wouldn't it be possible then, since we have these 5 or 6 big topics of recommendations that we do all have consensus on, and we have all come up with a process together that we really worked out all the details and we worked out all the language and we all are on the same page, that to me is a very different process and a very different outcome than this piece where we're just going to do, it sounds like a straight up and down majority vote, knowing though that this is not a consensus and we're not getting there. Why couldn't we just make this a recommendation that says, you know, X members of the group believed that 50% annually without a final deadline makes sense, and Y members of the group believe that a final deadline makes sense of, I don't know, 2027. I don't know, I'm just throwing together. Why are we acting like these are the same processes when they're very different processes? And it's very clear that there's a pretty big disagreement with the final language here.
I'm not acting like these are the same processes. Folks were able to work out through consensus a lot of recommendations, but it leaves a few issues unresolved, which are these remaining issues. And we need to take a vote on those. The report can reflect that some were agreed to by consensus of the parties. And the report can reflect what the vote was when it came to the rest of the recommendations. But I do think we do need to include recommendations when it comes to timeline and when it comes to the seclusion ban itself, and include those in our final report. Ms. Hulse.
Madam Chair, I did have a question in about the language in Part A. Just as somebody who theoretically would be interpreting this, when I look at the seclusion used less than 5% of the time, just in the way we talk about seclusion, I would want to add some language to that and know what we mean by that. And what I mean by that is that on no less than 5% of school days? Is that used in no less than 5% of critical incidents? I think that would be helpful for school folks, or perhaps I'm being a little too exact right now, but looking at that from my vantage point, I wouldn't know what that meant.
Okay. I think that's a fair point. I think, Ms. Woodward, do you have any insight?
Yeah, so thank you, Madam Chair. I agree with Kate, and I was like processing through some suggestions for what that might look like. I did want to respond to Ms. Winship's comments just around restrictive procedures. If you look back at, like, I think it was our first meeting, the MDE report, I was doing some, it shows just that trend in time around, you know, physical holds versus seclusion, and we are showing, and again, I'm not a mathematician, but about a 26% increase in physical hold since the ban took place. And I think if we're following the track of this analogy we've been using, which is the alternate assessment with this threshold recommendation, I think that when we talk about things like the MTAS, or where we're limited in doing certain things, we talk about it in terms of number of students. And so that might be an opportunity between this meeting and next to take a closer look at the current rate of use. If you look at that same, and that might be a better threshold. So for example, no more than 1% of students enrolled in a district are to be taking the MTAS. So that's very clear. I can take the number of students taking the MTAS and the number of students who are enrolled in the district, and I do a calculation and I see if I'm above or over or below that threshold. And so I think what we're trying to do here, and I hear the frustration on the side of the advocates. You're asking for something and we're not giving it to you. And I can hear it and I understand it. At the same time, I feel like, as from a school district perspective, there are many, many things we're bringing to the table to add to address the specific concerns that have been brought around misuse and lack of accountability and procedural safeguards for parents. And so we're just trying, I know we're not saying yes to that big request, but we are trying to meet you in a space to acknowledge the use of the tool in some very narrow use cases with emergencies within our specialized programs. So I don't have the answer in terms of what the math would look like. Currently, compared to our entire student population, it's like 0.04% of kids are using seclusion. But we could mitigate, we could look at that within settings 3 and 4. What is that percentage and what would we want to get to? And is it below 1%? And how do we look at that? I don't know. I'm trying to come up with what some of those look like, but I do think looking at it as student percentage is likely easier to measure than a percentage of time.
All right, so let's put a pin in this one and let's come prepared to discuss it and vote on it next time. Is that fair? Okay. And we can think about what metrics might be workable. And it's an idea. Bill language will incorporate specifics, but I mean, I hear what you're saying. If we can get it to some workable language that is understandable and implementable, that's kind of my goal. So this first one had to do with timelines. All right, are we good to move on to B? Okay. So looking at B. Item B was a recommendation that Minnesota statute 125A0942 subdivision 2. That's here. Be amended to include lines 1.26 through 2.13 of the 0077 amendment. And I've got that pulled up on the screen here. See if I can make it bigger. So looking for a recommendation that 125A042 subdivision 2 and let's put a pin in this, that if the use of seclusion as a restricted procedure for children in grades 1 through 6 or 1 through 12 must be explicitly agreed to. These are the explicit agreement provisions. I think some of this overlaps a little bit with some of the other stuff that we agreed to last time. But it does make explicit agreement by parents and guardians, informed written consent separate from other IEP provisions in the parent's primary language, affirmative versus passive consent, and then triggering a new IEP meeting if seclusion is used on 2 separate school days within 20 calendar days to discuss the effectiveness of the continued use, other options, and showing the parents and guardians where the room has where seclusion has occurred or may occur in the future. Kind of ignoring the grades 1 through 6, because we're going to talk about grades 1 through 12 next. Putting a pin in that. Any thoughts on this language as proposed? Ms. Heiser.
Thank you, Madam Chair. Might be helpful to ask MDE to create a standardized separate consent form here so that districts don't have to do it on their own. Okay.
Ms. Woodward.
Thank you, Madam Chair. Ms. Heiser, I'm so glad you said that because I was thinking the same thing when we were talking last week. And we were talking about some of those other, again, procedural safeguards that we wanted to put in place. Things like making sure the parents saw the room, et cetera. We discussed alternatives and you could include those pieces right on that form with check boxes to kind of go through again to make sure that we're not missing anything and there's lots of transparency. So I think a separate form is a really good idea because it can capture all of those other pieces that we talked about.
Any other comments on the language in 1.26 through 2.13? All right, the second part of subsection B speaks to the same statute, 125A0942 subdivision 2. But we go down to this language, 3.1 through 3.8. The Commissioner of Education must provide outreach and education to parents or guardians of children subject to seclusion as a restricted procedure, including but not limited to what seclusion is and is not, an explanation regarding the appropriate uses of seclusion, then that it is a safety procedure to be used only in cases of emergency, what constitutes an emergency, and information regarding legal safeguards surrounding the use of seclusion. Ms. Sandsmark.
Thank you, Madam Chair. I apologize. I was trying to raise my hand and missed the boat on the first part of the section, and so I don't mean to take things out of order. But just just want to clarify, are we talking about in lines 1.26 through 2.13? Are we talking about the grades 1 through 6 part of this amendment, or are we leaving all talk about grades until later in the discussion? I just misunderstood, I think. Just want to make sure.
We're going to talk about grades in a second. I want to see if there's any issues, if there's language we need to change here. We've got the MDE drafting a separate consent form. And before we agree to anything, we're gonna discuss the grades as well.
Okay,
No?
I appreciate that clarification, and we can move on to the section that you just brought up. Thank you.
Okay. Any comments on 3.1 through 3.8? For Ms. Sandsmark or Ms. Heiser, is there anything else that MDE could do, should do, you'd like to see them do to assist family members, parents, caregivers of students to assist them with access to this information or access to the complaint process? I think there were a few things that we talked about, and I can't remember if they're in the recommendations we achieved by consensus when it comes to the school report card or a portal on the MDE website or something like that. Ms. Sandsmark.
I would be curious to see if there was any addition, perhaps, of having a specific line item for complaint process for seclusion specifically. Ms. Heiser brought up a component. MDE will work with districts to provide a support and technical assistance necessary. I think it would be great. We have the report cards, excellent. We love that we have access to those things, but making sure it's really visible and clear about complaint processes would be a minimum, I think, for us. And that's where I'm at right now, just thinking about that language, open to other suggestions. But if whatever we can do to line item it and separate it out from other things would be great.
All right, I'm taking some notes. So I'm going to power through some of the stuff. We're going to go back to the chair's recommendations and go from there. Letter C, looking at amending Minnesota Statute 125A0942 subdivision 4. So we're moving, oh, that's 3. Moving to 4. To include lines 6.2 through 6.24 as set forth in the amendment 0077. And here's where I included changing it to read grades 1 through grade 12. So what I heard discussion last time was, why do 1 through 6? Why not 1 through 12? I think that's totally fair. If we're talking about the use of seclusion, if we were to incorporate these changes in the amendment and it would include 1 through 12, I'm wondering what the feedback is of the group on that. Ms. Woodward.
Thank you, Madam Chair. From a MACE perspective, we would support expanding these changes to grades 1 through 12. Because, and again, the reason that I think some of our recommendations included 1 through 6 is just to be in alignment with where some of the current bans on non-exclusionary discipline or exclusionary discipline and seclusion were going. But for an implementation purpose, it also makes things easier if we do things the same across the grade span. So there's no concerns on that change from MACE perspective.
Any other comments? All right, is anybody opposed to expanding this discussion from grades 1 through 6 to grades 1 through 12? Ms. Chose?
Yeah, I think, that rollback from third, I'm concerned about the impact of rolling back the K through 3 seclusion and the impact that will have. I'm struggling with the how that will happen and the message that sends when we're also trying to move towards the end of seclusion, and putting those teachers kind of back in that position. So yeah, I'm concerned about doing that. That's
The
all.
idea is to address the concerns and the difficulties that we've heard from the school community, and trying to not roll back, but provide availability to a tool that they were not ready to give up yet, with additional safeguards for the use of that tool. So, I mean, you can call it a rollback, you can call it a retooling. I think the straight ban, we spent a lot of time talking about how that hasn't worked, how it's been difficult, how it's left folks with an inability to address emergency situations without somebody getting hurt. And so the idea is that we are retooling the restriction on seclusion with a goal toward ultimately ending it, while acknowledging that a straight ban caused more harm than good for some folks. And to be clear, it would be grades 1, 2, and 3, because kindergarten, if you look up online 6.2 and 6.3, it would still be banned there.
Right. Thank you, Madam Chair, for that. I think I tried to catch up in my reading, but having missed the beginning of this working group, I think I missed some of that as well. So thank you.
Yeah, certainly it's not, the idea is not to roll back anything. It's to take into consideration some of the harm that we did when we enacted the ban, and provide an easier kind of glidescape ramping to undo some of that harm with the end goal still in sight. Ms. Sandsmark?
Thank you, Madam Chair. At SNS and for my vote, I would not be able to approve of anything that in our eyes would change the current ban. However, I'm interested in language that protects the usage of seclusion and protects the usage against, excuse me, let me rephrase this. The changes that are proposed on the 1 through 6 that are mentioned in this part of the amendment are interesting, and I would like them to be used 4th grade through 12th. But in our coalition, we would like to see the current ban on and no use of seclusion 1 through 3 to maintain itself. And if it was going to be an expansion of the usage of these practices through 12th grade, that would be fantastic. But rolling back and allowing the use of seclusion even through parent permission 1 through 3, we cannot agree with. And I also wanted to really quickly go back to Miss Winship at the very, earlier on in this discussion talked about MDE data from 2024, but that data was not reporting current seclusion, the current seclusion ban and restraints now, just FYI on that. And I would hope that, and I would caution this group in general when speaking about the use of restraints and use of seclusion and talking about that there's a causation there. We don't have that fully yet. We have data from school districts. We have data from a lot of folks in this room, which is great. But what we don't have is, what we have is correlation. And that's not the same as a specific causal relationship. So I want there to be a little bit of room in there for that. Not all the data is in yet. So just want to open that up for discussion, or at least just to make that point. But I would love to see, if for this amendment specifically, a fourth grade through 12th and to maintain the current ban. So that's where we sit. Thank you.
Thank you, Ms. Sandsmark. And I think we discussed, when we discussed the data, that we certainly couldn't assume there was any causation. We were simply noting that the numbers that we're seeing suggest or certainly show that there are increases in physical holds and injuries. We certainly can't correlate that to the elimination of seclusion, but it's data that I think is useful. Ms. Woodward.
Thank you, Madam Chair. Yeah, I don't recall that when, kind of responding to Ms. Winship's inquiry, that I had said that it was causal. I simply, am pointing out that it has increased since the ban was put in place. And like, that's just what we're looking at, that was the specific question. And I think it's really important to note that what we're talking about in C, and I know the concern around those current grades, but right now, the current requirements for the use of seclusion are a registered seclusion room and an emergency. And that's really it. And so I think that I, again, want to just acknowledge that we are bringing a lot to the table and expanding a lot of procedural safeguards and limitations for the use of seclusion grades 1 through 12 that aren't even for grades 4 through 12 currently in place. And we're really coming with some flexibility. This will have an impact on districts. It will change practice. It will protect. It will limit to a substantially greater degree than it is now. And so I don't want to lose sight in that piece, because I do think that it's important to note, and in C, we're greatly expanding and in support of doing so, protections for kids grades 1 through 12.
Yep. It's what we call in the industry here a compromise. And I think it's important to reflect and remember, we've had these really difficult conversations. Everybody's kind of given a little and expressed where they're coming from and what's important to them. And these are the last pieces where we do not have consensus. We're going to try to get as close to it as we can, understanding that Ms. Sandsmark and Ms. Heiser remain committed to the complete abolition of seclusion under any context, sooner rather than later. Understood and noted. We're trying to find a compromise here. Ms. Heiser.
I think you just said a lot of what I was going to say, Madam Chair. Nicole, future Dr. Woodward, I appreciate your point about trying to find compromise. I gotta be honest, like we're moving just as much towards the middle here. In 2022, 2023, there was an enormous amount of compromise where MDE and several of the advocates were leaning towards a complete ban of seclusion. And this birth through 3 was the compromise. And that was with the intermediates and MDE and advocates and parents all sitting down and working this out with the legislators. So this K-3 ban is this tiny little baby step that we have taken in the right direction. We've all acknowledged it's the right direction. And so we've taken this baby step towards our baby learners, our littlest learners. If we wanted a unanimous vote on this amendment, add the extra protections and put in 4th through 12th grade. And I'm not sitting here pushing for a total ban. I've taken that off the table because I know we're trying to get somewhere. But to roll back the K-3 that has been in place and you were given a ramp up to it. We passed it and said it's not going to be in effect for a year and a half. And there's been significant decreases in the amount of seclusion that have happened in that short amount of time. We've taken a step forward. We can't get rid of K-3 at this point. So, I think if we want some sort of, consensus and unanimous vote, then adding these extra protections in through 4 through 12 and, speaking on behalf of the Protection and Advocacy Agency, we'll walk away from the push for the total ban. But under no circumstances can we roll back the very small progress we've made as a state. And I know that that's just a different viewpoint. I know that Senator Seeberger has said this is a tool and it was disastrous to remove it. I have a very different view of that. And I think that the data doesn't support that it was disastrous. I think we have 40% less seclusion in the state, and that's a good thing. So, if we want to talk about 4 through 12, I think we could get there. If you want to roll back K-3, I don't think there's any way we're going to get there.
I hear you. Yep. And bears repeating, had I known this was in the bill in 2023, I would have voted no. So it wouldn't have passed. It did not have the majority support of the legislature because I was a no. All right. Setting aside the grade 4 through 12 or the 1 through 12, any other discussion on the rest of the safeguards and provisions in 6.4 through 6.24? All right, seeing none, I'm going to move on. Section D of the chair's recommendations is that Minnesota Statute Chapter 125A be amended to add Section 125A.101 as set forth in line 6.25 to 6.27 of the amendment 007-7. Any comments on 6.25 through 6.27? All right. Is there anybody who cannot support this? Ms. Hulse?
Oh, that was just a thumbs up.
Oh, okay, a thumbs up. Thank you. Okay, you're like this big on my screen. Perfect. All right, I'm gonna go back to, I'm gonna stop sharing for a minute. Nope, not that. And going back to the chair's agenda or the chair's recommendations. All right, we've put a pin in A. We're gonna hammer that out next time. B, what I've done is change the language to change our grades 1 through grade 12. And that MDE will draft a separate consent form specific to the use of seclusion and MDE will develop a streamlined and easy-to-use process for complaints relating to seclusion restrictive procedures, something like that. We can have Mr. George put it in better language, but that would be the recommendation to include as a bullet point on the duties and responsibilities of MDE. Any thoughts on recommendation B? All right. Mr. George, I would like to move that section B of the chair's recommendations, as we're looking at them right now, as amended, as we've discussed, be recommended to be included in our report to the legislature. Can you call a roll call, please, on the vote?
Yes, Madam Chair, give me 1 second. Chair Seeberger,
Yes.
Senator Coleman,
Yes.
Representative Engen,
Yes.
Representative Sensor-Mura,
No.
Kim Baker is excused, Heather Halstead's excused, Jamie Harthen's excused, Dave Haveman,
Yes.
Jessica Heiser,
No.
Kate Hulse,
Yes.
Fatima Molas,
No.
James Schmidtke is excused, Aaron Sandsmark,
No.
Greta Chose,
No.
Melissa Winship,
No.
Nicole Woodward,
Yes.
Madam Chair, there are 6 ayes, 6 noes, and 4 absent.
All right. A tie does not pass. So the motion does not pass, and chair's recommendations in paragraph B are not recommended to be included in the report. I will make a motion to adopt the chair's recommendations in paragraph C in the document that I'm sharing right now. Mr. George, will you take a roll call?
Madam Chair,
Yes.
apologies, Chair Seeberger, Senator Coleman,
Yes.
Representative Engen,
Yes.
Representative Sensor-Mura,
Sorry, I am not remembering which one. Can I either get an explanation or I will need to pass it this time? I'm not remembering what this one refers to.
This is to include the line 6.2 to 6.24 in 007-7, changing it from 1 to 6 to 1 to 12.
Yes.
Ms. Baker's excused, Heather Halstead's excused, Jamie Harthen's excused, Dave Haveman,
Yes.
Jessica Heiser,
No.
Kate Hulse,
Yes.
Fatima Molas,
No.
James Schmidtke's excused, Aaron Sandsmark,
No.
Greta Chose,
I guess I was a little confused. I thought that the last one was including it from grades 1 through 12. So can you clarify B and C?
Yes, in B, as we were discussing it, the language spoke only to grades 1 through 6, and we put a pin in the discussion whether we wanted to increase it 1 through 12, which we did when we talked about section C, and so I made the changes relating to section B as well.
Okay, but section B gets more to protections around IEPs,
It does.
not necessarily, okay. Okay, then I'd say no on C.
Melissa Winship,
No.
Nicole Woodward,
Yes.
Madam Chair, there are 7 ayes, 5 noes, and 4 absent.
Sorry, I would like to change my vote for that one.
So George, what's the process for changing a vote when the roll is closed?
Senator, we could. I guess thinking back the of the roll, I announced the vote. Let's see.
Madam Chair, may I make a motion to not reopen the roll call?
Could make a motion to do that, or make a motion to reopen the roll call is essentially the process.
Okay. Representative Engen, I didn't hear what your suggestion was. Can you repeat that?
I'd like to make a motion not to reopen the roll call.
Any discussion on Mr. Engen's motion? Hearing none, all in favor say aye.
Aye.
Aye. Any opposed,
Aye.
say no.
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 All right, motion carries. We're not gonna open the roll call. The roll call was closed. I think we have a vote of 7-5 on adopting C. I'm sorry, Representative Sensormero. So item C, motion carries on item C. And
Is there a way for it to be noted that I would like my vote changed? I mean, that was not an accurate vote for me.
yeah, that's why we're in this predicament, because I wouldn't have voted for the seclusion ban in the first place. So you and I are both in the same boat here. But it's noted that you had sought to change your vote and was unable to do so before the roll closed. So Chair's recommendation C will be included as a part of the draft report. Moving on to Chair's recommendation D, I'd like to make a motion that Minnesota Statute Chapter 125A be amended to add sections 125A 101 as set forth in line 625 through 627. Actually, that's not my motion, strike that. My motion is that Chair's recommendation D be adopted as a recommendation in our draft report. Mr. George, will you take a roll?
Madam Chair, this is D, you said?
D, yep,
Thank you. Madam Chair,
yes.
Senator Coleman,
Yes.
Representative Engen,
Yes.
Representative Sensormero,
Pass.
You abstain?
No,
You're a no?
I am a no.
Okay.
Representative Sensormero, no. Kim Baker excused, Heather Halstead excused, Jamie Harthan excused, Dave Haveman,
Yes.
Jessica Heiser,
No.
Kate Hulse,
Yes.
Fatima Molas,
No.
James Schmidtke's excused, Aaron Sandsmark,
No.
Greta Chose,
No.
Melissa Winship,
No.
Nicole Woodward,
Yes.
Madam Chair, there are 6 ayes, 6 noes, and 4 absent.
All right, on a tie, the motion fails, so chair's recommendation D does not pass. All right. I am going to, give me 1 second here. Okay, the final, chair's recommendation is E. Actually, before we do that. So I'm going to recap what we voted against or what did not pass. We did not agree to provide a notice of procedural safeguards in the oral translation to parents of a child with disabilities. That's what this group did not agree to by a vote of 6-6. And I'm puzzled why folks wouldn't want MDE to develop and maintain an oral translation of the notice for procedural safeguards provided to the parents of a child with disabilities. This was chair's recommendation D. So we had opportunity to talk about it. Nobody had any objections to it. Yes, yet 6 people voted against it. Puzzling. We voted against directing the Commissioner of Education to provide outreach and education to parents and guardians of children subject to the use of seclusion, including the suggestion for the line item things, including a streamlined procedure for reporting complaints about seclusion, and for drafting a separate consent form. We also voted against these additional safeguards when it comes to seclusion. So puzzled as to why we might want to do that, but that's what we did. Moving on to the final recommendation, chair's recommendation, letter E. MDE and or the legislature must evaluate the elimination of, of seclusion to determine if the data shows that the use of restrictive procedures has increased. Students must also be evaluated for trauma associated with the use of restrictive holds. If the data shows that the use of restrictive holds has increased in relation to the decrease in the use of seclusion, then schools must be allowed to use seclusion subject to the provisions of 125A 0942 subdivision 4. I threw that in there as I was in another task force today thinking about where this might leave us, because what I certainly don't want to do is take away a tool that leads to additional trauma for other students. So I would open this up for discussion and thoughts. Representative Sensor-Mura.
Thank you, Madam Chair. It was actually, I was going back to what you were previously talking about what we did not pass. So I am wondering for lines 1.26 and 1.27, could there be agreement with this group if we changed grades 1 through 6 to grades 4 through 12?
I understand your question, but what this does now is I would like to see this applicable to grades 1 through 12. Given that we have agreed as a group to recommend 6.4 through 6.24 going 1 through 12. In addition, it doesn't get to, by changing 1.26 and 1.27 to grades 4 through 12, it doesn't get to the problem identified by the school districts and by Senator Seeberger with regard to the outright ban on seclusion. We get to the heart of the issue, the heart of the dispute. Ms. Heiser.
Madam Chair, I would make a motion that if we were to change Chair's recommendations B, C, D, and E to grades 4 through 12 and take a roll call vote on all 4 of those motions for grades 4 through 12. That's my motion.
E does not deal with grades, any grades. D is simply the oral translation component, and C has already passed. So, it seems to me your motion is specific to Chair's recommendation B.
Let me amend my motion. My motion, would you mind pulling up your screen for the Chair's recommendations again? That might be
Got it.
helpful for all of us to look at.
So D is the oral language piece. C already passed.
I'm sorry, I'm not seeing it on my screen. Does anyone
Are
else?
you
see
not
it?
seeing? What are you seeing?
I'm still seeing your amendment.
All right, stand by.
Thank you.
Better?
Thank you very much.
Yep.
I amend my motion. My motion is to take a vote on B, changing it to read grades 4 through 12 and all of these additional protections, to reopen the vote on C, grades 4 through 12 and adding those protections. And D and E would stand.
We are not reopening the vote on C. D was defeated. E we haven't voted on yet. So I believe the motion is strictly with regard to Chair's recommendation, paragraph B, changing the grades instead of 1 through 12 to read 4 through 12. Is that your motion, Ms. Heiser?
If we're not willing to make B and C match grade wise, then I would withdraw my motion for B. If you're not willing to reopen the vote on C, then the motion on B doesn't make any sense.
Okay, so Ms. Heiser withdraws her motion. Ms. Woodward?
Thank you, Madam Chair. I'm just, there's a lot here, so I'm concerned, but the next steps for A through D have been clarified, in terms of like, we're not reopening the vote and changing, and I'm just concerned because we're missing an opportunity, because I think we're just missing an opportunity to protect kids. And that just weighs heavy on me. For E, my one comment, given where we're heading, is as I'm looking at it very carefully, students must also be evaluated for trauma associated with the use of restrictive holds. That particular sentence, has a lot of different meanings in the context of the school system. So an evaluation just wanting to be really thoughtful about what that sentence means and how that could be interpreted in terms of responsibility for things like comprehensive evaluation or who does an evaluation. I think we're looking for and trying to address signs of trauma, which I fully support. I just don't want to agree to something that has one intent and then it ends up being another thing that maybe we weren't intending because of the word evaluated has a very specific definition within special education.
Mhm. All right, any other comments? We're on E. I'll put brackets around that. Or maybe not. Does anyone else have any other input on E? Oh, look, it's where it went. Ms. Halls?
Only that I think we should be consistent with the use of language in E. Senator Sieber, I appreciate that at the bottom of E or the last sentence of E, we talk about the use of restrictive holds. In the first sentence of E, we talk about the use of restrictive procedures. I think having matching language there would be helpful, calling them restrictive holds or physical holds. I think would get at exactly what we're looking at. Because we're really looking for, are we seeing an increase in the use of holds with a decrease in the use of seclusion? So I think matching language in that particular area would be helpful.
Representative Sensor-Mura.
Thanks, everyone, and apologies for being the person that messed up. But I do just want to be on record that, I think everyone saw I did not mean to vote for C, and I actually think I agree. C without B is worse than it would be. So just want to put on record that was not my intent to vote for C without B. I think that there's a lot of good things in B, but I do not support rolling back the ban, which is why I voted against it. I think those are really good protections that I would love to see for other grades. I think C without B is actually worse. So I feel like it's kind of like, oh, got you, but like this is not what I wanted to vote for. I actually don't think this is like really the outcome that anyone wanted, so it's too bad like that we're basing this off of my mistake, but I did make a mistake and like procedurally, we are where we are, but I want it on record like I don't think this is a good outcome.
I understand. I made a mistake in 2023. That's why we're here. I didn't mean to vote yes to the ban on seclusion. So you and I understand each other. Back to subsection E. If I leave the word evaluated in brackets, understanding that it's an opportunity to go in and gather some data on what's going on with our students, can we trust that the proper wordsmithing will occur later on? Okay. So with the understanding that we'll get the wording right, I would move that the working group adopt chair's recommendation, paragraph E, to be included in the recommendations of the working group report. Mr. George, will you take a roll?
Chair Seeberger,
Yes.
Senator Coleman,
Yes.
Representative Engen,
Yes.
Representative Sensor-Mura,
No.
Kim Baker's excused, Heather Halstead's excused, Jamie Harthen's excused, Dave Haveman,
Yes.
Jessica Heiser,
No.
Kate Hulse,
Yes.
Fatima Molas,
No.
James Schmidt-Keys excused, Aaron Sandsmark,
No.
Greta Chose,
No.
Melissa Winship,
No.
Nicole Woodward,
Yes.
Madam Chair, there are 6 ayes, 6 noes, and 4 absent.
All right. Motion fails on a tie. Any other recommendations we wanted to discuss for inclusion in the work group report? All right, we will come prepared to discuss Chair's recommendation A next time, and we should have a draft report in almost final form for us to review at that time. Let's see. Mr. George, is there anything else? I don't have my agenda in front of me. Oh, wait, here we go. I think that's it.
Madam Chair, Representative Sensenbrenner has her hand up.
Representative Sensenbrenner.
Thank you, Madam Chair. Will there be a vote on the final report?
I believe there will. Mr. George?
Madam Chair, so next week, a vote on this final outstanding paragraph A of the chair's recommendations. Everything that has been voted on that has passed will be in a draft final report. Then that draft, and then there will be a final vote on adopting that report as the working group's report to the legislature, and that'll be the final vote. Yeah.
So you can vote it down then, Representative Sensenbrenner, and we will have nothing to present to the legislature. You'll have that opportunity. So that includes all the stuff that we reached by consensus. All right, our next meeting is, Mr. George, when is it? Next Wednesday, 2 to 4?
Madam Chair, next meeting, Wednesday, January 28th in the Senate building, 11:50 at 2 p.m. Yeah.
All right, and that'll be our last meeting. So with no further business before the working group, we are adjourned. Thank you, everyone.